I'm going to apologize ahead of time. Some of these slides are very intense because it's just statutes straight from the website, so I'll do my best to kind of walk you through to navigate to some extent. My only disclosure is I had my best friend, attorney friend, help me with some of the statutes because it's like total legal talk. So, all right. Yeah, again, unfortunately, I have no financial relationship. So we're basically today for the next, it will be shorter than an hour. So understand the laws and rules for a licensed osteopathic physician in the state of Florida, how we find these statutes and kind of sift through everything online, and knowledge of the overall disciplinary process in the state of Florida. That was a fun conversation to have with my friend, how that worked. Okay, this is tiny. I have it here on my laptop so I can kind of walk you through it. This is one of the required courses for the state license. The license for this past cycle was up on March 31st. If you're doing this course now, you're too late. This course will apply to your license currently, which expires in 2018. Few things you have to do. If you change your address, it has to be on file within 15 days with the state of Florida, okay? If you don't do that, your license is put into a delinquent status, which you don't want to do that. If you are in an inactive status, meaning that you're not practicing medicine for 2 consecutive cycles with the state of Florida, and then you want to become active again, they may or may not make you either do a test to see if you're still competent or to do certain CME courses. When you do renew your license, obviously most of it's done online now. So you have a renewal application, you have to pay your fees, you have to update your practitioner profile, which is your location, if you have a PA, nurse practitioner, awards, recognitions, website, email, that kind of thing. You also have a physician workforce survey online as well as a financial responsibility form. All of these are online, just kind of you hit next and it just puts you through everything you need to do. So for this current cycle, this really hasn't changed. So you have to have 20 general hours of AOA Category 1. Then you also need 15 hours of general hours, which can be AOA or AMA. The following lectures have to be live. So medical errors has to be live, professional and medical ethics has to be live, Florida laws and rules is live, and prescribing of controlled substances, which you just had, has to be a live lecture. You have total of 40 hours that have to be reported. And then every third renewal period, you have to do 2 hours of domestic violence. I just want to say this gets complicated, right? Because you have to have certain things for your license in the state of Florida, and then you have to have certain licenses or certain requirements for each of your boards. And now you have osteopathic continuing certification too. So make sure you're hitting everything you need to hit with all of them because they don't all cross over. What I found out with my continuing certification, I thought my cardiology training while I was in training would count towards my OCC, and it did not. So I had to do my 10 credits within like 3 months for my AOBIM. So you just, if any of you are teaching and you have fellows or anything, you might want to make sure that they're keeping up with their OCC while they're in fellowship. Okay, so any updates can be made, and this is the website, it's floridaosteopathicmedicine.gov. And then any resources that you need can all be found through that website. Any update at all, with the exception of getting married, unless you changed your name, or having children, needs to be updated, okay? So name changes, address changes, any hospital privileges. If you have nurse practitioners or PAs that work under you, if they don't work under you anymore, it needs to be repeated. If you have new ones, they need to know about it. Convicted of a crime, anything, you have to report it to the state within 15 days. That's the cutoff. Okay, so when I did these updates, I kind of picked the things that I thought were the most important for, first of all, anything that was actually updated since last year, and then also things that I thought were kind of important for everyone to know. So in terms of sexual misconduct, what's considered sexual misconduct? Basically, we'll skip down. A patient shall be presumed to be incapable of giving free, full, and informed consent to sexual activity with his or her physician. This crosses over to any immediate relative as well. So guardian representative of the patient or immediate family member, this is them as well. So if you have a patient and you want to have relations with the brother or the sister of the patient does need to be, you need to stop seeing them as their physician. They have to basically be discharged from your practice before you can engage in any sexual conduct. Kind of silly, but does not only mean penetration. You can't thrust or touch or do a gyne exam without gloves. Okay, that's not good. So all considered sexual misconduct. Okay, not that we haven't hit this over the head 1,000 times this morning, but in Florida, if you're treating chronic non-malignant pain, you have to be registered as a prescribing physician of controlled substances. If you're giving Tussie and X because someone's got a cough, that doesn't count. Okay, if you're continuously prescribing pain medications for chronic malignant pain, the state has to know about it. You have to register, and there is a registration fee. It will be updated online on your practitioner profile as well. All right, so this is what I thought was most important. So this is what the state requires if you're a registered physician and you are prescribing these medications. This is what they're requiring. Your medical record has to have, at a minimum, documentation of the nature and intensity of the pain, current and past treatments for that pain, underlying or coexisting diseases or conditions, the effect of the pain on physical and psychological function, a review of all previous medical records, previous diagnostic studies, and a history of alcohol or substance abuse has to be addressed. So on your initial documentation, all of this has to be addressed. If you want to talk about CYA and people coming after you, in the state of Florida, this all needs to be addressed. Okay? Also, medical record, and these are pulled directly from the statute website, directly. The medical record shall also document the presence of one or more recognized medical indications for the use of a controlled substance. Each registrant must develop a written plan for assessing each patient's risk of aberrant drug-related behavior, which may include patient drug testing, as the previous speaker talked about. Registrants must assess each patient's risk for drug-related behavior and monitor that risk on an ongoing basis with the plan. A written individualized treatment plan has to be done for each patient. Next, the physician shall discuss the risks and benefits of the use of controlled substances, including the risks and abuses of addiction. This has to be documented. The physician shall use a written controlled substance agreement between the physician and the patient outlining the patient's responsibilities, okay? You have to excuse me because I didn't sit in for, I was here for the second half of the last lecture, but what I do as well for my patients that, not for pain, but other controlled substances like the phentermine, they have to tell me what pharmacy they're using. That's it. I need a pharmacy, I need a phone number. If I ever call that pharmacy and you didn't pick it up from there, you're gone. I want to know what pharmacy you're using. The patient shall be seen by the physician at regular intervals, not to exceed 3 months, to assess the efficacy of treatment, to ensure it's still working, progress towards treatment objectives, and considering adverse drug effects, and reviewing the ongoing etiology of the pain. Okay? For each state you practice in, you have to have a separate DEA. So if you're in Florida and New Jersey and you're prescribing pain medications, you have to have separate DEA numbers for each state that you're in. Okay, now that we've beat opiates over the head 1,000 times, we're going to be done with that for today. Okay. So adverse events in an office setting, things that have to be reported. All right. Again, I apologize, it's a complicated slide, but I really wanted to pull the exact verbiage from the website, so you don't think I'm making it up, okay? Because it can be slightly ridiculous. So if you're in the office and you're seeing a patient, what considers an adverse event that has to be recorded or reported to the state? Obviously, a patient dies in your office, okay? So this is where it gets interesting. So I ask my friend, who's an attorney, and I say, okay, let's say I'm a cardiologist. Someone comes to my office, and we're doing a stress test, and he codes and he dies in my office. I have to report that? He said, yep. And I said, well, that's not from he says, it has to be reported. He's like, they probably won't do anything with it, but if you want to make sure that no one's you need to report it. Okay, so. Brain or spinal damage, performance of a surgical procedure on the wrong patient or wrong site. So if any of that happens, if you're doing some kind of minimal, minor plastic surgery in the office and there's a cyst on the left leg and you took out a freckle on the right leg, that has to be reported, okay? Performance of a wrong surgical procedure, surgical damage to the patient resulting from something that was not signed on the consent or something that is not a known problem from that particular procedure. So, if they get an local infection from a local incision, that's one thing. But if something else happens that is not a recognized complication of that procedure, it has to be reported. Obviously, unplanned foreign objects, a procedure to remove those foreign objects has to be reported. And if you are transferring a patient to a hospital from an ambulatory surgical center, that has to be reported. Okay, so if something happened in an ambulatory surgical center and they're having to be transported to the hospital, that has to be reported. So if I copied directly from the statutes for this, it would have been the entire presentation. Apparently, there's a lot of rules with doing surgery in your office, because I know there's a lot of people who are doing minimal plastic surgery and some liposuction in the office. There is a lot of rules and regulations when it comes to this. So basically, I call it the what kind of plastic surgery are you allowed to do in the office rule, okay? They even have defined how many cc's of supernatant fat you're allowed to remove in your office. And if it goes over that, it can't be done in your office. I mean, it's ridiculous. How the anesthesia records need to be done. How many nurses you have to have per patient in your office for the different procedures that you're doing. So, what I implore you to do, if you're doing any type, especially any type of plastics in your office, you need to read these and make sure that you're keeping records appropriately and you have the right staffing that you're supposed to have. Okay, financial responsibility statements. If you're not going to carry malpractice insurance, it has to be posted in your office. This is exactly what it has to say. It came straight from the website. Copy it, print it, put it in your office if you don't have it. So it says, under Florida law, osteopathic physicians are generally required to carry malpractice, blah, blah, and in capital letters, your osteopathic physician has decided not to carry medical malpractice insurance. Okay, it's permitted, as long as you have a certain amount of money in the bank, but this has to be posted if you do not have malpractice insurance. Walk into an OBGYN's office, you'll find it. You have to list on any of your advertising that you are a DO. I cannot put Dr. Tiffany Sizemore-Rees. I have to put DO after my name. I have to. It has to be on anything that goes out. Letterhead, business cards, prescription pads, everything, okay? If you are saying that you specialize in something, you better really specialize in it, meaning that you had to have completed a fellowship. I can't say I practice cardiology if I did 2 years and I quit. You have to have completed the fellowship to say you're a specialist, and if you're boarded, you better still be boarded. If you're saying I'm board certified in cardiology, you better have an active board certification in cardiology, okay? So again, you can't even imply the fact that you're some sort of specialist, and I have an example. Again, failing to identify through written notice, which may include the wearing of a name tag, or orally to the patient any type of license under which the practitioner is practicing. Any advertisement for healthcare services naming the practitioner must identify the type of license the practitioner holds. So in our state, if you're going to advertise on a billboard, in a newspaper, or anything that you hand out, it has to say you're a DO. Okay, I'm going to read this because I'm doing this because I actually asked a lot of my friends and colleagues, and no one agreed on what kind of doctor this person was. So it says, this doctor started treating these conditions over 16 years ago. There's few schools that teach vein care. He joined various vein societies that meet several times a year and learned the more advanced procedures. He's also studied under other doctors who were considered the best in the field. He had to travel all over the country to hone his skills. He carefully and slowly developed Fort Lauderdale Varicose Vein Clinic. Today, he's proud to be one of the best in his field. What type of doctor is he? Guess. I just want to hear the guesses. It's fun. Vascular surgeon. Chiropractor. Some kind of PhD. Physiatrist. He's a podiatrist. Ask me how long it took to find on his website he was a podiatrist. 10 minutes, figuring out. Because I had a patient going to him, and this is what happened. This is how I found out. He calls my husband and says over the phone, I'm doing a vein ablation or something on your patient, and I need her cleared for surgery. And my husband says, well, then you need to send her back. And he goes, well, I just want you to clear over the phone. He's like, that's not how it works. You need to, and he has to raise his voice with him because he's like, I'm not going to clear someone for surgery. You're doing a procedure on one of my patients. I need to know what she's having done, when it's being done, what kind of anesthesia, and she needs to come back. And he gets upset. So then I kind of play half office manager in my office. So then I have to go and figure out who this guy is. And I call and they pick up the phone and they still don't identify on the phone who they are. So I call and then I email the patient and I said, listen, I know I'm not your doctor, but you saw my husband. And I said, are you aware that the doctor you're going to is not a medical doctor, went to medical school, he's a podiatrist? And she says, what? And she's like, well, what do you mean? I go, he's a podiatrist. And she's like, he never told me he was a podiatrist. And so for that reason, now he could be the best in the field, but there's something within me. I can't refer to this guy. I mean, he's not being truthful, right? I mean, you should be telling people you're a podiatrist. And he probably is awesome. So she got referred to actually a DO who is a vein specialist in our area. But I do this because you need to understand that if we can't figure out what this guy does, to be sure, patients can't figure it out either. Right? So if you look, this is pulled straight from the Department of Health website. Okay? So we have a clear and active license expiring in 2018. And if we look, it says, the first line says Palmetto General Hospital internship, AOA approved, from July 2010 to 6/2011, so that kind of makes sense, right? And then family practice residency from 7/2011 to 6/2013, which was the 2 years after the internship, so that makes sense. Now it says something aesthetics, residency, plastic surgery in Salem, Virginia from October 2010 to November 2010. Last time I checked, a residency is not a month. And then Miami aesthetic plastic surgery. Now, mind you, these are the dates that he was in residency in family practice. So someone's listing publicly, and I don't know how this got through, that he was doing residency in plastic surgery while he was in family practice residency. I find out from my program, these were his rotations. So if that's the case, I'm an ophthalmologist, a dermatologist, a nephrologist, right? So when we talk about problems, this is health grades listed as specializes in cosmetic surgery. Okay? This is from health grades as well, saying that he does with breast augmentation, silicone or saline implants. This is a non-board certified family practitioner. And this is when I actually get angry, right? Because these are people's lives, and he's doing this in the office. This is like license can be taken away, big time. So, and I do this not because, and there's 1,000 Perez's DOs, so I didn't, but I do this because I need you guys to understand that it happens. I know this person, and it's really bad, and it's scary, and patients are seeing them. So this is the kind of stuff that you don't want to be punitive, but this needs to be reported because people are going to him and seeing him thinking he's a plastic surgeon, and he's not even boarded in family practice. All right. So if you have nurse practitioners or PAs and it's primary care, you are allowed to supervise at 4 other locations beyond your base camp. If you're a specialty practice, you can supervise at only 2 other offices besides your base camp, no more than that. You have to post the hours that the physician is there at those secondary sites. Okay, so Dr. Smith is only here on Monday, Wednesdays, and Fridays from 8 to noon. So the patients know that if they're seeing a nurse practitioner that the doctor is not in the building. Interestingly enough, if a nurse practitioner or a PA is doing anything when it comes to skin care services, they can only be supervised by a plastic surgeon or a dermatologist. They cannot be supervised by anyone else if they're doing skin care services. If there is electrolysis or electrology using laser or light-based hair removal or therapy, the physician has to be within the 4 walls of the office while it's being done. Okay, so no electrolysis or using lasers for anything unless the physician is within the 4 walls of the office. Direct supervision. Bless you. Okay, so important specific statutes. Growth hormone. Denial of licensure or disciplinary actions if you are prescribing HCG or other hormones for muscle building or growth hormone for muscle building or weight loss. Cannot prescribe it, okay? You cannot prescribe growth hormone because someone wants bigger muscles. Disciplinary action. This was just an article from CBS News that basically said what I said, that people, they want to stay young forever, so they're using growth hormone. It says at 39 years old, growing old is a case of mind over matter. Okay. Obesity trends in the United States. So if we look on the top left, it was 1990, followed by 1999, and then 2008. So if we look at Florida, back in 1990, we had about 10 to 14% obesity. In 2008, that went up to 20 to 24%. So it's a problem. It's a problem amongst everyone in our country. So touching on what I said before, in order to prescribe obesity medications, very strict rules have to be followed. If someone does not have any comorbid problems, meaning they're not diabetic, they're not hypertensive, they don't have hyperlipidemia, their BMI has to be greater than or equal to 30. If they do have comorbid problems, the BMI has to be greater than or equal to 25. Now, the rules with this are a little lax, because what you constitute as hyperlipidemia might be different than how I constitute hyperlipidemia. So if you're going to do it with a BMI of 26, you better be documenting that, oh, the LDL is 140, and I really think the benefits outweigh the risks, and if they lose weight, then they don't have to be on statins, and so on and so forth. But if someone's got an LDL of 80, that's not going to work, right? So you need to be able to justify why you're doing it. Patient does have to have written informed consent. There has to be a face-to-face encounter. Personally, my patients see me every week, the first 2 weeks, then they go to biweekly, then they go to monthly. I never see these patients every 3 months on phentermine, ever. They, at a minimum, see me once a month. They do have to be handed the Weight Loss Consumer Bill of Rights, which can be found online anywhere. And when I tell you that my patients that are on phentermine, when they have to sign about their signature or their initials in about 15 different places, they do. Because, again, this is something people look for this because it works, but it's basically speed. So if someone, there's a lot of people who use this not for weight loss, they use it for other reasons. And just like the other gentleman was saying, if they lose it, oh well, you don't get a prescription until your next appointment. I do not refill this stuff early, ever. But it works. It really does work, and it's got its place, but you need to make sure you're following the rules. Okay, so false advertisement in regards to weight loss. You cannot promise specific results. You can't say guaranteed to lose 15 pounds in 1 week. That's illegal. You can't do that, okay? Unreasonable expectations. Claim rapid or dramatic, incredible, or safe weight loss. There is no such thing as safe weight loss on phentermine, okay? It's as safe as any other medication, all right? I've had only one adverse event. I had a guy go into rapid AFib on it. Did he have a propensity to have AFib anyways? Yeah, but it happens, okay? So you can't say it's safe. State or suggest that diets or exercise are not required, or suggest that weight loss is effortless or magical. Things we're not allowed to do. So this, can't do it. Amazing breakthroughs. Safe medical weight loss. These are not things we're allowed to say in advertisements. Okay, reporting of communicable diseases. Again, a slew of things that have to be reported. FloridaHealth.gov, it's basically, you can actually print it out and maybe laminate it. It's kind of like the size of half of a piece of paper, and it lists all of the reportable diseases and when they have to be reported. These are reported to your local health department. This is not at a state level, it's reported locally. Some are reported immediately, some reported even if it's suspected, and some can be reported the next day. And other information is typically required as well. And this is what it looks like on the Florida Department of Health website. And what's in red has to be reported immediately, and then in black can wait until the next business day. But you'd be surprised there's some things on here, and I think that at a minimum we should all have this at least printed and somewhere in our office to kind of refer to. All right, telemedicine. So it's like when you're Googling and there's an ad at the top that says, do you want Viagra? Just fill out this form and we'll send it to your house. So this is what this is about. So prescribing medications based solely on an electronic medical questionnaire is not allowed. It cannot be a questionnaire. Can you do telemedicine? Sure. But you need to have documented a history and physical exam that's pertinent to the patient's complaint, okay? So it says, an osteopathic physician shall not provide treatment recommendations, including issuing a prescription via electronic or other means, unless the following elements have been met. A documented patient evaluation, including history and physical, adequate to establish the diagnosis for which any drug is being prescribed. So if you're a dermatologist and someone wants to video chat with you, and you look and you know and you can see it, and you know it's ringworm and it's and you can document that you saw it on the video, that's fine. But you need to be able to document that what you're prescribing is okay based upon what you saw. Okay? Sufficient dialogue between the osteopathic physician and the patient regarding treatment options and risks, and maintenance of medical records as usual. Okay, so if you're going to video chat, you need to at least document that you did it, what you saw, the treatment that was given, and follow up if necessary. What we are not allowed to do is prescribe based solely on a questionnaire. There still has to be somewhat of a face-to-face, even if it's face-to-video to face. Okay?
Treating a suspected urinary tract infection would be out of the question.
You know, I thought about that, and I don't think so. Because even then, how many times do patients come to your office, right? And maybe you don't have dipstick UA in the office, and you treat them and you still send them to the lab. So technically, I would say that's probably safe as long as you're still giving them a prescription to have urine drawn. Because there's a lot of physicians who treat the UTIs and they don't necessarily have UA dipsticks in the office. But again, I think it's just a matter of documenting appropriately. And I think, it's kind of like a yeast infection in a woman, right? I mean, if you're a woman, you know when you have one. You'd be hard-pressed to find a doctor that still does an exam for that, because they know, right? Okay, so requirements for written records. You have to keep records for 5 years. This includes everything: the histories, the exam, records of the drugs prescribed, consultations, and whatever consultations you you still have to keep them, and reports of hospitalization. So 5 years worth of written records have to be kept for each patient. Okay, surgery, and this isn't just in your office, this is in general, but let's use it for now for your office. Obviously, an informed consent, the physician does not have to witness the patient signing the informed consent. The physician will have to sign it, but you don't have to witness the patient signing it. Timeout has to be done by the physician. I'll say that again. Timeout has to be done by the physician. It's not done by the nurse, it's done by the physician, okay? Name, the identification number, telephone number, date of birth, social security number, address, or photographs are all usable in terms of identifying it's the correct patient, okay? You do not have to do timeout for minor surgeries. What is not considered a minor surgery? Paracenteses, thoracentesis, ocular surgery, any sort of liposuction, lipoplasty, a Mohs surgery is not considered a minor surgery. Timeouts have to be done and documented for these. All right. So the fun part, what happens when we get a complaint? So we have a whole bunch of people that govern us in the state of Florida. So we have the Department of Health, who licenses us, the Board of Osteopathic Medicine, who makes our rules and hears the disciplinary hearings, the Attorney General's office, who provides the attorney for the Board of Osteopathic Medicine as general counsel. They also provide attorneys from prosecution services to represent the Department of Health during prosecution of a physician. There's a District Court of Appeals who hears the appeals from the board and the DOH, and then there's the Division of Administrative Hearings who hears the formal hearings for disciplinary actions, okay? So when we're getting investigated, how does this actually begin, all right? So it can be done a few ways. Someone can complain and actually sign the letter, and it's a written complaint. There can be an anonymous complaint, or a confidential informant complaint, or an actual Department of Health investigation, okay? What happens is if this happens to you, you'll get something called a notice of investigation saying that you're being investigated, okay? You have 45 days, and you have to provide a written response as to your response as to what the complaint was about, and basically justifying it, okay? I implore you to never do this by yourself, okay? Get an attorney. Please, get an attorney, all right? If this goes to the probable cause panel, which I'm going to talk to you about, it has to be considered in probable cause. So your letter will be considered in any decisions that are made. So write the letter and make sure it's a very well-written letter with an attorney that looks at it, because it will be looked at and it will be taken into consideration if anything goes to probable cause. The only exceptions about receiving this letter is if it's a criminal charge or if they think sending the letter will be detrimental to the investigation. Those are the two instances where you might not even know you're being investigated. Okay, so what happens? A Department of Health investigator is going to call you, and you're not going to talk to them because you learned that from Law & Order SVU, okay? Don't talk. Everything you do needs to be through an attorney. Everything. Do not speak to anyone from the state of Florida. Get an attorney, talk to the attorney, and let your attorney talk to the Department of Health investigator. Okay? This is why. A physician in the state of Florida, was a DO, and had a complaint because apparently someone just hated him about his letterhead did not say DO on it. It just said Dr. Robert Smith. So they made a complaint. Okay? And he thought that was ridiculous, and it kind of is, and that should have just been a citation and been done with it. But he didn't think he needed an attorney, so he wrote a letter. And guess what letterhead he used? The same letterhead without the DO on it. So now this is a second violation. So now he went from a citation to a real problem because it's the second time the same thing happened. Okay? So when it comes to law, you're not smarter than an attorney. Let the attorney do it. Okay? So this is what happens. 3 things. You either, it's reviewed, the complaint is reviewed, and it's decided it's nothing, don't worry about it. That's option 1, that's the best option. As my friend said, congratulations, you have some 28-year-old right out of law school determining that, so have fun. Or you are issued a citation, okay, in which case you receive a notice of citation and you have to comply with whatever that citation is, okay, and we're going to get into what that is. Or you could go to something called a probable cause panel, and you'll have to excuse me because that probable cause review should actually be an arrow going over to probable cause found. So if it goes to the probable cause panel, that letter you wrote, that is what is considered in the probable cause panel. So they look at it and they say, well, this is what this person says, and this is the doctor's response, and then they kind of make a decision, okay? So if no probable cause is found by the probable cause committee, then you're off. So it's basically like you were off from the beginning, okay? It's just that a committee of people reviewed it, all right? If probable cause is found, the violation is made public, it's public record, and it cannot be disputed, okay? Then we go into you having a formal charge. When you have a formal charge, you get something called an election of rights letter, and that is where you and your attorney have to decide how you want to proceed further, okay? Do you want a formal hearing? Do you want an informal hearing? Or do you want to settle? Okay? If you have a formal hearing, you're basically considered a criminal. It's just like a criminal case. You never, ever, ever, ever do this without an attorney. Okay? It's like judge, jury, whole 9 yards. Formal hearing. All right? That's a formal Department of Health hearing. An informal hearing is heard before the Board of Osteopathic Medicine. The physician cannot dispute the results. Okay? However, the physician is able to present testimony and evidence or request leniency in the violation. Okay? The Board of Osteopathic Medicine then may increase, decrease, or dismiss the case altogether. Okay? So still with an informal hearing, you have an opportunity that your case is completely dismissed. Okay? But at the same time, the board can also say, you know what, we disagree with the probable cause panel. We think it's worse than what they said, and they can make it worse. Okay? Or you can settle and have some sort of settlement agreement, whether it be with CMEs or license restrictions or so on and so forth. So what are things that could potentially be a citation? Again, the advertisement is usually a citation. If you fail to say you're a DO, someone reports that on a business card or something. That's usually just a citation. It's a fine. You pay it. You don't do it again. Falsely certifying compliance with continuing medical education. That's usually a citation. You're fined about $2,000 for that. Failure to keep current mailing address, that's a $250 fine and a citation. Failure to register as a dispensing practitioner. If you're dispensing medications from your office, that's a $500 fine and a citation. Failure to report to the board within 30 days after you've basically been found guilty of some sort of crime, that's an $800 fine. And this is where it gets a little wishy-washy because you're supposed to report that stuff within 15 days, not 30. But in this particular statute, it says 30. But any changes is 15. So, okay, so if you get a citation and you don't dispute it within 30 days, it's considered the fact that you're accepting it and it's final order and you have to pay the fines and you have to do what they told you to do in terms of a final order. Failure to pay the fines and costs will constitute another violation, and that's going to be more disciplinary action. So now you've elevated from a citation to something that will probably go to probable cause panel. Once the citation becomes a final order, the citation and complaint become public record, unless it's exempt from a certain chapter, and the citation and complaint may be considered as aggravating circumstances in future disciplinary actions, right? So it's public record, it might be something small, but still your patients can find it, and then if something happens to you in the future, unfortunately, they're gonna use that against you if you have a citation, okay? See, I told you it'd be quick. Questions? No? Okay, thanks.